A very fantastic panel on the role of the courts and enforcing securities regulation. And it is my great privilege, first and foremost, to introduce Judge Jordan. Judge Jordan is a judge of the Federal Appeals Court of the Third Circuit in the U.S. He is an eminent and extremely well-regarded jurist in the U.S. With an expertise in corporate and commercial law. Judge Jordan has really excelled in commercial and corporate law throughout his career. He began in private practice, rising to the status of a partner in a top Delaware law firm. After that, he began his career in public service in the federal judicial system, not being nominated to the rank of the Federal Appeals Court in 2006. He has really developed a reputation of excellence on the bench, particularly for his work in corporate and commercial work and his understanding of the tremendously complicated, the sort of high-paced litigation that is coming up in Delaware, as well as, of course, in the U.S. Federal Circuit, as we heard today. But perhaps speaking to the judge's character most of all, we have known him at Vanderbilt for a number of years, as he has been a guest professor with us for a long time. And as you can see from the judge's 6 foot and a lot stature, he might look an intimidating person, particularly given his immense stature on the bench. But from conversations I've had with the students, they all uniformly speak to his tremendous decency, his kindness, his gentleness, his patience in trying to explain tough and difficult concepts in intellectual property to them, and really leaving them better off on account of having taken his class. So I think that statement really speaks to him as a person, as an educator, and I hope that education really comes forward in that discussion today as he teaches us about enforcing securities regulation. So with that, I'd like to welcome Judge Jordan for the evening panel.
Thank you. Thanks very much, Yesha. Let's sit by right here. Thanks kindly, and I appreciate that very nice introduction, Yesha, and I'm extra happy that my wife was here to hear it. And I also appreciate all of you being here this evening. I know you were torn. There was the opportunity probably to be at the Ambani wedding, but you came here. So I appreciate your making that choice. I am honored to be here. I spent part of my childhood here in India, and so having the opportunity to return and to bring my wife is a special privilege for me. The sights, the sounds, the sense, the spirit of the country has brought back a flood of memories for me, and it's hard for me to believe how much time has passed since I was a grade schooler here. But time does march on. I know it's affecting me. I had the experience a couple of years ago of going to Tokyo for a lecture, and I took the train from Narita Airport into the center city, and I was supposed to be met by a law student, and I got there and there was no law student. So after a few minutes I was starting to get worried, and then a breathless young guy came running up to me and said, "Are you Judge Jordan?" I said, "Yes." We were both relieved. He said, "You know, I've been looking all over for you. My professor gave me a picture of you." And then he looked at the picture, and then he looked at me. And then he looked down at his feet and kind of mumbled, "Must be an old picture." So I'm glad none of you greeted me by reminding me that I'm rapidly aging. If my faculties don't fail me, I'm going to talk this evening about security enforcement as it's done in the United States. And it's important that I give you a disclaimer right up front. I am not holding myself out as a great expert in this field. I'm a generalist, like most judges. And I learn what I need to learn for each case. And that's what I've done when I've found myself confronted with security cases, as I have from time to time in my career. This evening I hope to make the not very novel point that, like most everything in life, there is a golden mean to be found in regulating financial markets, a sound balance between hyper-regulation and unfettered freedom. First, I'm going to give a quick overview of how securities enforcement operates in the United States at the state and federal levels, both through public and private enforcement. And two things with regard to that I should mention. One is much of what I wanted to say. You heard from Professor Thomas this morning. We did not coordinate, and he had hit a lot of this stuff, so I'm going to try to shorten it up on the fly. The second thing I want to note is I recited my remarks to my dear wife, Michelle, today, and she slept through the entire part of it that had to do with the securities enforcement, the state and federal part. So try to stay awake if you can. The other thing that I hope to accomplish after giving you this quick tour of federal and a sample of state law enforcement of securities in the U.S. is to talk briefly about examples on the extremes. That is, how the system can fail both with under-enforcement and with what I think may be over-enforcement. And my aim, again, is simply to show that policymakers, including legislators and regulators and judges, should be looking for a balance for that golden mean. So let's start with the overview of state law. And I'm embarrassed to say, I don't have any PowerPoint slides. So you're just going to have to imagine words whooshing in from the side and sound effects periodically, all right? While the majority of securities enforcement occurs at the federal level, there is state enforcement, both by state officials enforcing the securities laws in that state and by investors bringing suits under corporate law. It's often intertwined with federal securities enforcement. And this is something that Randall hit well and thoroughly this morning. Every state has its own securities laws, commonly known as blue sky laws, and they're enforced by state securities regulators, and every state's got a securities regulator. Those laws vary from state to state, but generally they require companies offering securities to register them before offering them in the state, unless the offering is subject to some exemption. State securities regulators also end up licensing brokerage firms, brokers, and investment bankers and representatives, but only insofar as they operate in that particular state. In Delaware, where I'm from, the Delaware Securities Act, as well as the rules and regulations promulgated under that act, are enforced by the Investor Protection Unit of the state's Department of Justice. Recall from this morning how Professor Thomas discussed the shifting of laws in the federal and the state system with the 1995 enactment of the Private Litigation Securities Reform Act by the U.S. Congress, putting some pressure, as he put it, on a balloon so that cases sort of tended to move into the state system, and then pressure on the state system, at least in Delaware, with in 2015 and 2016, with common law changes in the Delaware Court of Chancery's approach to disclosure-only settlements in merger and acquisition class actions. And you can see that skilled lawyers don't have a hard time figuring out how to frame their complaint as either a breach of fiduciary duty claim under Delaware law or a lack of disclosure claim under the securities law. Skilled lawyers know how to sing both those tunes and sing it in the circumstances they want to. And one commentator at least had noted that beginning in '95, much of the private litigation surrounding public company mergers that had traditionally been brought as federal securities claims was instead being brought as state corporate law claims, particularly in Delaware, and as you heard this morning, that dropped dramatically in the last couple years with the In re Trulia case, the Corwin case, and others that have changed Delaware law. But it's true that there are still plenty of instances in which a case against a corporation for violating United States securities laws spawns a parallel suit invoking state law principles. Thus, under the framework of state corporate law, the Delaware state courts routinely decide cases that affect or are related to securities disclosure. So that's public and private enforcement on the state side in a very condensed form. Turning now to the federal enforcement, we see where the bulk of securities enforcement occurs. And again, that's both public and private mechanisms in operation. The primary federal securities statutes are the Securities Act of 1933 and the Securities Exchange Act of 1934. For some reason, the Securities Act of 33 is called the 33 Act, but the Securities Exchange Act of 34 is called the Exchange Act. The impetus for those statutes was the United States stock market crash in 1929 and the follow-on depression that caused a great deal of demand for reform in the American financial system and led to numerous changes, including primarily those two statutes, and an entire regulatory edifice has been erected on those. The central aim of the securities statutes and the laws and regulations built around them is disclosure. The 33 Act focuses on disclosure for securities offerings and their issuers, while the Exchange Act is focused on disclosure in the secondary markets. The goal is to give the public information it needs to make sound decisions about buying and selling, and of course to prevent fraud. Looking first at public enforcement, are enforced through civil and criminal actions as well as by administrative procedures, and this is done primarily by the Securities and Exchange Commission, which you know is called the SEC, or often simply referred to simply as the Commission. On the civil side, the SEC has broad investigative powers and can file civil enforcement actions in federal court. Those actions allow it to obtain a court order enjoining an individual from further violations, disgorgement orders that require the turning over of money obtained from illegal conduct, and in some circumstances, civil penalties. Also, in dealing with foreign operations of U.S. companies, there can be action taken by the SEC to enforce the Foreign Corrupt Practices Act of '77, and that's also done under the bribery provisions of Section 30A of the Exchange Act. And the Commission can, through its administrative disciplinary proceedings, take other actions. It can bar firms from acting as securities firm or investment advisors, and bar individuals from associating with them, or bar professionals from practice before the Commission. So their administrative authority is enormous. On the criminal side, the Department of Justice of the United States can pursue criminal violations, and of course those remedies involve jail time and fines that can be substantial. And the fact that a person is subject to a criminal prosecution does not mean that they won't also be subject to civil enforcement remedies by the SEC. Those are not mutually exclusive, and it's not unusual for people to face both, and that sometimes leads to lawsuits where somebody wants to say, I'm in effect being exposed to punishment for the same problem twice, and the answer is usually not really, because civil penalties are not criminal penalties, and so, yeah, you're getting whacked twice, but in a different way. It's not much comfort to them, but both of those can be enforced against the same person. The private enforcement is usually in the form of class actions, and that also plays an enormous role in the enforcement of federal securities laws. The 33 Act contains express private rights of action, and courts have implied private rights of action under the 34 Act, maybe most notably under Section 10B of the Exchange Act and SEC Rule 10b-5, but also, very importantly, under Section 14A of the Exchange Act, which produces a lot of the disclosure cases that we're talking about. It requires full and accurate disclosures in connection with proxy solicitations. And Section 14E likewise requires full and open disclosure in relation to tender offers. Cases brought under these sections and rules frequently allege that a company and key figures made false statements or withheld information, which when revealed to the market caused a drop in the market price, and they are commonly pursued, as I said, as class actions. Now, Congress wanted to put a brake on that because they had the sense, again, as you've heard earlier in the day, that things were getting out of control, that lawsuits were proliferating that had no merit, and so they enacted the Private Securities Litigation Reform Act. I want to just say a couple things about that real quickly. It was expressly designed to curb the routine filing of lawsuits against issuers of securities and others whenever a significant change in an issuer's stock price occurred, without regard to any underlying culpability and only the faint hope that the discovery process, which you know exists in American legal system, would produce some plausible cause of action. And among the things it did, and this was very significant, there were some obvious and important things that practitioners in the United States are well familiar with. It ramped up the pleading standard so that you have to plead with particularity your allegations of fraud or lack of disclosure with scienter. It also imposed a mandatory stay of discovery, and it gave judges the authority to select the lead counsel in cases. Now that has some significance because it was meant to damp the race to the courthouse, where lawyers would just be out of the gate, try to be the first one in, and because of that, get some primacy of position. I mean, there are other effects that has, but it's very significant that the court is in the position of saying, no, you're going to be the lead counsel, and there are some pretty ugly fights around that. Who gets to run that show? In this regard, there was a Supreme Court case just this year that dealt with follow-on legislation to the PSLRA. And people respond to incentives, right? So the plaintiff's bar is no different. When the PSLRA came in, attorneys quickly realized that they could avoid the PSLRA's heightened pleading standards and other problems or things they viewed as problems by filing their securities class actions in state courts. And so Congress responded in '98 by passing the Securities Litigation Uniform Standards Act. So they acted pretty quickly on that. And among other things, it was meant to and had indeed, I think, expressly the purpose of preventing plaintiffs from seeking to evade the protections of federal law against abusive litigation. Okay? That was the aim. And yet this year, just a few months ago, the Supreme Court of the United States, in a unanimous decision, held that the 33 Act can be enforced in state court, and that those cases are not removable to federal court. So I would say the law is full of surprises. Forum shopping is going to get a boost out of this. But in the end, since most of these cases that are brought typically under the Exchange Act and not the 33 Act, it may be that the practical effect of that decision, the Cyan case, will not be that large. All right. All that is a lengthy background to say this system, this set of broad powers given to public enforcers and the rights that are given to private individuals to sue must have some kind of restraints on them, and that falls some to the courts, but also to legislators and regulators and policymakers like yourselves to be thinking about how do we keep the enforcement so it's just right. Balance is an ideal that mankind has been seeking forever, right? Aristotle is the one who I think gave us the name, the golden mean, and he used the example of courage. He said, we admire physical courage in a person. You get too little of it, and it's cowardice. You get too much of it, and it's recklessness. If you don't like Aristotle, go with Goldilocks. She was looking for the porridge that was just right, not too hot, not too cold, just in the middle. That's what we're looking for, the porridge that's just right. It is possible to be too lenient and to be too strict. And an infamous case came to light 10 years ago that shows the too lenient side. It is almost 10 years to the day since Bernie Madoff was let off in handcuffs from his offices in New York City. Now, that's a name that's probably familiar to many of you. He was the author of the greatest, biggest Ponzi scheme in history. You know, a Ponzi scheme is a fraud in which rather than paying investors with money from the productive enterprise, you pay them with funds that come from later investors. And of course, that can only last as long as there are later investors when the whole thing collapses. Madoff ultimately pled guilty to 11 felony counts. And those included, obviously, securities and investment advice or fraud counts. It was reported that he lost, and it was hard to estimate it, but it was in the tens of billions of dollars of investor money. Let me read you just a snippet of a news report from shortly after he was sentenced. So this is from October of 2009, and it gives you a sense of this problem of under-enforcement. This is what the reporter wrote. As Bernard Madoff sat in jail a few months after pleading guilty to fraud, he sounded faintly boastful. The only problem with officials at the SEC's headquarters, he said, is that he had too much credibility with them and they dismissed the idea that he was scheming people out of billions of dollars. Madoff says he had the impression that it never entered the SEC's mind that it was a Ponzi scheme. He seemed convinced that the SEC staff did not suspect him despite the agency's numerous probes of his business. And he said in an interview that the SEC examiners never asked for basic records to corroborate his operations. The disgraced financier also confided that he didn't bring an attorney with him when he testified in an inquiry, and he was trying to fool the government investigators into thinking he had nothing to hide. Now, that kind of, you could maybe chalk that up to hubris and say, oh, he just said that stuff because he was, believing he was above it all. But I think the reality is he was saying that stuff because indeed he was above it all. He wasn't investigated on basic things. And he ended up getting the maximum sentence, 150 years, so he'll spend the rest of his life in jail. But there may not have been nearly so much damage, nor the need for such an extraordinary sentence, had there not been problematic under enforcement. Now, having said that, I would say there are certainly plenty of cases of very aggressive enforcement too. And I would think sometimes too aggressive. I'm a former federal prosecutor myself, so I've got a great deal of admiration for the men and women who have to make decisions about who to charge with what and when and what remedies to seek. So this is not so much in the nature of a criticism as an observation that there can be legitimate disagreement with those judgment calls at times. And I want to give you just one example from my own work. A few years ago, I wrote a dissenting opinion in a case called SEC versus TIO, which was about the disgorgement of fraudulently obtained profits. Now the SEC gets a lot of money, literally billions of dollars, sometimes billions in a single year, from disgorgement orders. Those orders are to supposedly make the government whole or make victims whole from the ill-gotten gains. They're not a criminal penalty, the penalty is a disgorgement order. Well, this individual, the defendant, Mr. Tio, had gradually increased his ownership share of a publicly traded corporation without making the necessary disclosures. Entirely independently of that, another corporation came along and made an all-cash tender offer for that company. The SEC later filed a civil enforcement action, and a jury found that the defendant had violated various securities laws. The district court ordered the defendant and a related trust to disgorge the profits from the transaction. The defendant, not surprisingly, appealed the district court's disgorgement order, arguing that the SEC should be required to prove that the securities violation was a direct and proximate cause of his allegedly illicit gains. Now, you may be familiar with this, but in the United States, at the appeals level, decisions are made in panels of 3 judges. So I sat with 2 of my colleagues, we heard this appeal. My 2 colleagues who were in the majority were willing to defer to the SEC, and I thought that was a mistake then. I still think it was a mistake. And I said the majority paid lip service to the limiting principle that to avoid being a punitive measure, a disgorgement order must be limited to ill-gotten gains. My colleagues did not actually apply that principle to the admitted premium associated with the tender offer. It was admitted, as it had to be, that the tender offer affected the price. It affected this man's gains, but that didn't matter to the SEC or to my colleagues. He had to give it all up, and in my view, that changed it from a disgorgement order to a penalty more in the nature of a criminal sanction. But anyway, a little too aggressive in the nature of enforcement, in my view. The need for proportionality exists on the private side as well. I don't want to spend too much time on this. My time is probably far spent already, but I will remind you of things you've heard earlier in the conference, including things from Professor Thomas, that there came a period, particularly after the 1995 Private Securities Litigation Reform Act, where an enormous number of merger class action challenges were being filed in the state courts, particularly in Delaware. So much so that I think one figure I saw was, and this was borne out by Randall's slides today, 95% of the cases where the M&A value of the company was in excess of $100 million, 95% of those drew a lawsuit, a challenge in court. Now, you got to believe that in there is a large, healthy number of bogus lawsuits. But what happens? You get a disclosure-only settlement. Plaintiffs' lawyers walk away with literally, sometimes, millions and millions of dollars in fees, and you can see why that kept happening. We don't have to go into how the common law was adjusted to deal with that. That was talked about earlier. But I will note that the fact that those suits exist and still exist, and indeed now are ramping up in response to the Delaware clampdown on disclosure-only settlements, shows you that the problem hasn't gone away, and that the problems that the Private Securities Litigation Reform Act were meant to address are still very much with us. Within the last year or so, I was happily in the majority for a change in writing a decision for my court, where I noted that the case, which involved a 100-page complaint, it was truly a kitchen's, everything but the kitchen sink thrown into this complaint, had caused tremendous problems at every stage of the litigation because it was so hard to get a handle on what was being alleged. I wrote that the plaintiff's post hoc scouring of countless pages of public filings for a stray and inartfully phrased comment that can be argued to be technically false was just the kind of thing that the PLSRA was meant to eliminate. But there it was, big as life, just in the last year. I think in this respect, it's worth considering just for a moment, even though the business judgment rule is not part of our securities laws, remembering what that teaches. The point of the business judgment rule, and this is a very loose phrasing of it, is to say that barring some decent evidence to the contrary, we're going to believe and presume that the behavior of corporate fiduciaries is not always great in terms of judgment, but it is well motivated, that they're not trying to do the corporation dirty, that they're going to have the benefit of our believing that they're acting in good faith and for the best interests of the company. And without that protection, we will get suboptimal risk-taking. There's been a lot of talk about risk in this conference, but we want an appropriate level of risk-taking by our corporate managers. Otherwise, we're not going to get the returns we want. And the business judgment rule helps us manage that. That kind of thinking has perhaps not direct application, but some analogous application when we think about are we over-enforcing and are we retarding what we hope to get from good corporate directors and managers, which is a level of behavior that will bring returns as long as it's being done in good faith. I don't want you to get the wrong idea. Let me conclude with this thought. I am not suggesting that private enforcement is a bad idea. I understand, and I know you heard this afternoon a little bit about the law here in India that I understand was passed in 2013 that gives private rights of actions, class action opportunities for investors. I think that's likely to be a great thing for your securities enforcement. It certainly is an enormously important part of the American scene. Done right, it's a very healthy thing for the financial system. There's no way that public enforcement can cover all the ground that needs to be covered. You need people looking out for their own interests to a certain extent and having the right to sue. My hope and my suggestion here is only that these things are not self-calibrating. It takes a constant attention to the machinery of the systems of justice to make sure that we're not getting too little, we're not getting too much, we got the porridge just right. Thanks again for the privilege of speaking with you this evening.
So now we have a panel to discuss securities regulation featuring the inimitable Justice Sri Krishna, who will be joining us, of course, Professor Vikramaditya Khanna from University of Michigan Law School.
Thank you, Yesha. Now, in India, to start with, we had only the Contract Act of, 150 years or 120 years vintage. Subsequently, we got the Securities and Contracts Regulation Act, because when it was realized that a contract, although a security is a contract between two persons, it had some peculiar features which needed to be regulated. Even that act was found to be somewhat vague and generalized. Then we had the Securities and Exchange Board established under the act known as the Securities Exchange and Board Act, which gives enormous powers to the securities capital market regulator under a very vaguely worded section which says that he has all powers to ensure that there is no distortion of the market, in other words. Now, this would lead, as all of us lawyers would agree, too much discretion is always anathema to the rule of law. You have a rule of law where you have a rule which is capable of being understood by the person who is to deal with a situation, and a regulator who can understand what the rule is, so that when it comes to a question of enforcement, both the person who is suffering the enforcement and the person enforcing the rule are on the same page as far as the rule of law is concerned. Now, as far as the enforcement of securities regulation is concerned, I have a couple of highlights which I want to show as to where this is leading to virtually a breakdown of the rule of law as I understand it. Now, the first thing is, I happen to have headed that Financial Sector Legislative Reforms Commission in 2013, and we debated quite a lot, and one of the significant recommendations we have pointed out is that once an investigation has taken place and the supervisory team within the regulator believes that there have been violations, the principles of public administration suggest that the actual order should be written by a disinterested party. Now, way back in the law school, we were taught this Latin maxim, nemo judex sua causa, that whoever is an interested party should not make a judgment. How does it work in the regulatory field? Now, I hope you can read it, it's a little difficult. You have a board of the SEBI, then there are whole-time members, 1, 2, 3, 4. And the unfortunate thing is, there is no Chinese wall which separates the adjudicatory mechanism from the enforcement mechanism. Now, it's something like saying that the policeman himself will be the judge of a cause. Because of this, and also there is a very peculiar provision in the Act and the regulations that the whole-time member can at any given time pull out a case which is in the hands of the adjudicator, take it to himself on a review, either during the process or even after the process has been completed and a decision has been arrived at. This basically is a violation of the principle of natural justice. The result is seen in what happens in practice. What happens in practice is a show cause notice is given to a party, saying that you have done something or the other, which amounts to a violation, a distortion of the capital market, a disturbance in the capital market. So that person comes back and says, no, I don't agree with it because of these reasons. I cannot be charged with this kind of an accusation. The difficulty there is, it has started from the whole-time member who is a member of the board, because the board is the one that makes the, imagine the legislature making the legislation and also enforcing it and also deciding causes and effects. This is precisely the difficulty with the mechanism. Now, if you look at the securities regulations elsewhere, you will find that there are two distinct. Now, the Securities Exchange Commission, you will notice that the two aspects are clearly demarcated and they do not interlap with each other. There is no overlap between the quasi-judicial function and the legislative and the executive function. Now, this kind of a function needs, this kind of a setup needs to be done if the regulation is effective. It is true that now you can also see Financial Conduct Authority, how the description of investigation and enforcement process starts. There is an investigation, a report on preliminary findings, options before the person under investigation, either a settlement, make a submission before the RDC committee, which will comprise practitioners and non-practitioners operationally separate from the rest of the FCA, and has a team of support staff and its own legal advisors. Expedited reference then goes to a tribunal. RDC issues a decision notice, something like a show cause against why penalty should not, I have decided this, why should I not penalize you for this? Referral to the tribunal at the instance of a person against whom a decision of notice is issued. Now, the way it operates under our setup is that there is undoubtedly an appellate provision provided, at least in the with regard to the securities. There is what is known as Securities Appellate Tribunal. But somehow we find that there is too much deference to the securities SEBI, I'll call you the short term SEBI. On this ground, hey, this is an expert organization, I am not going to sit in appeal over that. The worst is when the matter comes to the highest forum in the country, namely there is a further appeal to the Supreme Court. The Supreme Court judges, I wanted to use a very strong word, I will not use it, shy away from it on the ground that, hey, this is a very highly technical situation. Technical board constituted under a special act has taken a particular view. Why should we interfere? Now, recently I came across a situation that securities, the SEBI is also responsible as a regulator of the exchange. Now, how the exchange functions, what is the price discovery mechanism, what is simultaneous trade are issues that need to be carefully understood before a judge dares to dive into this deep water. I saw a situation where there is a synchronized trading mechanism. The judges of the Supreme Court straight away jumped to this conclusion. Hey, a synchronized trade automatically means distortion of the market. There is lack of price discovery. Therefore, it is something that is wrong that needs to be dealt with in the disciplinary jurisdiction of the regulator. Now, this is somewhat, it struck a jarring note in my mind. Despite there being a synchronized trade, the question is how much of the synchronized trade took away and what portion of the securities that it did deal with. Now, are there other simultaneous trades happening before and after? So, is the price determined in the entire market only on the basis of two persons saying, yes, this is the agreed amount? Now, after all, the price discovery mechanism is the net result of all the trades that takes place during a particular given time. Now, if the judges had looked into it from this aspect of the matter, a wide sweeping observation saying that, every time there is synchronized trading, it automatically means that there is something very funny happening which needs to be interfered with. Why do they do that? They do it precisely for this reason, that they are not aware of the mechanism of how the stock exchange works. They think that SEBI is the one who understands stock exchange. I don't know anything, therefore whatever SEBI says I will accept. This is what the sense I got when I read the judgment. This causes a complete breakdown in the rule of law as far as regulatory enforcement of regulatory disciplinary jurisdiction is concerned. Now, I am glad to say that in the recent law that was enacted to deal with insolvency and bankruptcy, they picked up this thinking from the commission, the financial FSLRC, and took it and see how they have made it. This shows that somewhere along the line there is a complete demarcation of the regulatory from the enforcement jurisdiction, so that there is no overlapping at all. Now, both these aspects may vest in the same authority, but there should be some kind of a Chinese wall which separates them, which gives it at least an element of the principle of natural justice, that the same person who decides it is not going to enforce it and then come and say that I am going to adjudicate your case. Another aspect of the matter which struck me was the fraud is something that every lawyer understands, both in civil law as well as in criminal law. There are statutes which define what is fraud under the Contract Act statute. The Indian Penal Code says what is a fraud. In all these principles of fraud required an element of mens rea, saying that you did something with the intention of gaining yourself, causing loss to somebody, and what you did brought about this result. Now, apparently, the persons enforcing the regulatory rules were either unable to do their job properly, so they asked for an amendment in the regulation. What is the amendment? So, anybody who gives advice, as a result of which there may or may not be a loss caused to anybody, there may or may not be a gain caused to anybody, but it shall automatically amount to a fraud. So, if I was just giving an example and saying that if I were to tell Yesha and say, Yesha, go and put some money in XYZ share, because I think it's going to go up. She puts the money and she loses money. That's stock exchange. You put money, you lose money or gain money. So, am I going to be called a fraudster? Am I going to be punished for fraud and then told to disgorge whatever that by a disgorgement or whatever Asia has lost or whatever hundreds of investors have lost? This kind of generalized thinking is going to affect the development of the capital market in the long run. Fine. And another thing, the SEBI has a habit of shooting first, like the Wild West, shooting first and asking questions later. That was the norm during the Wild West in the 30s. What do? There is a regulation which deals with insider trading, fraudulent and unfair labor practice, unfair trade practices. They accuse somebody of insider trading or a fraudulent practice. Then they say, I am going to stop your access to the capital market until I am able to make up my mind. Fine, that's a correct way of going about, nothing wrong in that. But then when do you make up your mind? I know a case which was pending for 10 years. Now surely that is not the intention. Now if you can't make up your mind, if you can't come to a conclusion as to whether a person is really guilty of what is being accused or not guilty, why do you want to stop access to the market? The market has lost so much of investment, as a result of which what have you done? You have done precisely what the gentleman was trying to do. You have put a stop on the market, not allowing these securities to be traded. So the price mechanism of the market becomes a controlled price. Why? Because a large amount of stock was not allowed to be traded. You think that this particular person has done something that is objectionable. These are some of the aspects that need to be considered seriously. And then another thing, the financial sector regulatory financial sector laws reformatory commission had made a salutary recommendation. That was, before you bring in a regulation which affects the citizens, put it in the public domain, invite criticism on that, and then before you do something, have some kind of a balance sheet saying that what is the effect of my regulation, how much is it going to cost in terms of compliance cost, what is the evil that I am trying to overcome, balance the two, and if you are satisfied that the evil is far greater than the cost that is going to be there, that the benefit is there. This benefit cost analysis is very much required in every regulatory action. That is something lacking as far as I can see. That was something that was emphasized for in the Commission's report, but people are slow to pick up good things, as in life. Bad things are immediately picked up. Good things come later on after getting into this kind of a situation where you find that things have gone beyond your control. Friends, I think I have spoken enough. I have said enough about the market regulators, about the Supreme Court, and the rest is a matter of public. But I must tell you one more thing. Recently, just about last year, in fact, ending in July or August of last year, I was heading a commission which was looking into formulation of a Data Privacy Act. Now, one of the things we did was, we published what we called a white paper, saying that these are the tentative thinkings on the tentative thoughts on the subject, invited public participation, held public hearings in 3-4 major cities which are IT hubs, and then formulated a report, made a draft bill, gave it to the government, and of course the government is still sitting on that. I don't know what the government will do ultimately. But at least that gives an idea of what is the cost-benefit analysis. Now that is a fundamental principle which every regulator must follow, failing which we give a loaded gun in the hands of the regulator and we don't know whom he is going to shoot for what reason. Thank you very much.
I think this evening we are really lucky to have some of the finest minds in financial sector regulation in this room here. Of course, we heard Justice B.N. Srikrishna. We also have Mr. Sandeep Parekh, who is one of the leading thinkers in securities markets regulation in India. He's been with the regulator as part of their legal department. He now practices extensively in financial sector regulation. We also have Professor Vikramaditya Khanna, who needs no introduction here. He has worked extensively in the areas of corporate governance and continues to have a very deep interest in the way Indian finance and corporate governance works. So I think I'll just begin with, maybe each participant can make a 5-minute statement, and then probably we can address some questions and maybe then open it up to the floor.
Everyone here for inviting me. I found it's always a great pleasure and privilege to follow such distinguished jurists in talking about a topic as important as enforcement of securities regulation. I will say one of the most interesting things about working in this space is the fact that when you look at how securities regulation is actually implemented and enforced, so much seems to depend upon relative assessments of state capacity of the different institutions that you sort of charge to do the enforcement. So for example, in the US, typically when we talk about enforcement of securities regulation, it's some optimal mix, let's say, or presumed optimal mix of private enforcement and state enforcement. And when we think about state enforcement, we're typically thinking about some sort of regulator, like the SEC, and then maybe some backstop that includes, for example, say the Department of Justice bringing a criminal case against either individuals or corporations. In India, too, we think about enforcement in the same sort of way, but in differing measures. We have civil litigation, which is fairly nascent. state regulation, which is much heavier in some respects relative to private litigation, and the possibility of criminal enforcement, although the reality is perhaps not as preeminent as you might see in the United States. One question I think that comes up is why would various jurisdictions choose a different balance of how they decide to enforce a particular area of law? Why have a certain amount of private, a certain amount of public, and if you do public, why do you have some civil and some criminal? That optimal choice of enforcement seems to me to reflect both the institutional conditions that you see existing in a particular place, but also maybe the institutional aspirations that you might expect to see in a particular place. One of the fascinating things, of course, about India, as everybody in the room will know, is that relying on the courts to do enforcement in India is a fraught exercise, largely because of both the delays, but also the incredible pressures on the judiciary. Many of you will already be aware of the fact that the estimates seem to be that the 12,000 courts in India face approximately 33 million cases to address and resolve. That is quite a lot. I don't think you have to be a high-level math major to understand that that's a great deal of cases. That would be an average of 2,500 cases per court. To give you a rough sense of whether that's something that's affecting the lower judiciary in India or is it endemic, it's endemic. The Supreme Court of India varies, at least in the last decade or so, between 60 to 66,000 cases to address in a year. They, of course, can't address all that many in a year, but it's remarkable how many they actually do. Whereas if you were to take as a comparison the United States, the Supreme Court of the United States has somewhere between 85 to 95 cases a year, with a desire by both the current Chief Justice and the former Chief Justice to reduce that further. That suggests right then and there where you might expect to see enforcement and institutional capacities being stretched in India, and perhaps not as stretched in the United States. On the other side of the equation, if you look at the regulator, in the United States, the SEC has a budget that I think most businesses would be quite envious of. Typically, it's estimated to be in excess of $1 billion a year. No matter how much attention SEBI has received over the last 20 years, I think it would be optimistic to suggest that either in real or in nominal terms, their budget is anywhere near that level. Moreover, the process through which administrative regulation is put forward in India bears some similarity to that in the US, but the capacity constraints are quite different. So for example, in the US, one might often argue that securities regulators are able to attract top talent in ways that perhaps regulators in other countries can't. It's generally thought to be a very attractive proposition to a law graduate to go and work at the SEC, even as just an intern or an extern. Indeed, to work at the Department of Justice as an assistant US attorney is often thought to be the ticket to a prestigious partnership at a very, very expensive litigation boutique in the US. In India, that may or may not necessarily be true. I think that increasingly working at SEBI is thought to be a feather in your cap, but perhaps not to the extent that it was in the US and with the SEC. Working in the prosecutor's office, I don't think quite has the same cachet in India as it does in the United States. Again, that sort of suggests differing state capacities and institutional conditions. I think as we think about discussing the comments we've heard today and the discussions we've had in the various sessions, it would be interesting to reflect upon how those institutional conditions in India might lead us to change the way in which we think about allocating enforcement across the different areas, private, public civil, and public criminal. Just as a first thought, relying a lot on private litigation in India seems to be something of a fool's errand. It makes much more sense, I think, given the constraints on the courts, to think about the regulator playing a more active role. But at the same time, given the regulatory capacity constraints in India and the difficulty of keeping and attracting expertise, as my colleague to the left here, one wonders whether it might make sense to rely upon some other form of state enforcement as a supplement to simply relying upon SEBI, or maybe even charging up the criminal side in a way that might be more effective. With that, I'll hand over the floor to Sandeep.
Force and pros. It's much tougher to enforce because I think the real world comes in. It's very easy to write new regulations. We like the US in the 1930s, I think, which came out with this whole raft of economic laws, antitrust, securities. Our moment was, I guess, the early 1990s. Besides many scams, we also had, the opening of the economy, which resulted in very different dynamics. Earlier, you needed permission, actually. There was a controller of capital issues, and who was a bureaucrat sitting in Delhi, and you had to seek his permission before raising any capital, and at what price you could raise capital. So it was quite a bizarre world, and it was less than 30 years back, so it's not that far back. So we've of course come a very long way, despite the cynicism of Justice Sri Krishna. I think I think the reason I think the structure. I completely agree with all your points. I think the reason why this convoluted structure, and the convoluted structure is not made by SEBI, it's been made by the Parliament of India through the SEBI Act, is because they had to do something really fast. SEBI was actually set up in 1988 technically as an administrative body, but in 1992 I think they came across all these scams, the economy was opening, the dynamics were changing. I think they kind of came out with the law in somewhat of a hurry. It was actually an ordinance first, so it was obviously in a great hurry.
It's a knee-jerk reaction to what was happening on the ground.
Right. Having said that, in the afternoon you had a discussion on private enforcement, and Vikram and I have worked on a case together. Actually, we can discuss it today, I guess. It's pretty old now, Satyam, where both of us were expert witnesses in New York courts for the plaintiff's lawyers. It was a paid on the same side. I don't mess with you anyway. You've been punching people, I can see. He believes in private enforcement. Our expert opinion was that Indian statutes prohibit a private cause of action, and that's because of the way SEBI Act and SCRA are drafted. They actually exclude a civil suit in any case where SEBI has power, and SEBI has very vast powers. So whatever you discussed today in the afternoon applies actually to Companies Act. It does not apply to securities regulations. So even today's securities regulation, if there's a violation, you only have one recourse. Write a letter to SEBI. If they don't listen to you, too bad. You can file an appeal maybe. But it's everything is kind of focused on one regulatory body as opposed to being able to approach a court of law in a civil suit. So since civil suits are barred, obviously class actions are not possible. So I mean, we've been, in fact, well before the Satyam case, I've been writing articles seeking the repeal of these two sections so that we have a supplement of private cause of action. We have civil suits. We have. I don't see class action happening in India because we don't have contingency fees. But hopefully at some stage in life we will have that. Last bit I think is on during my time at SEBI we introduced the consent form, which of course we borrowed from the US, where the regulator agrees to settle or consent violations for a fee without admitting or denying guilt, and that was actually a huge success when it was introduced, and pendency was actually down to almost virtually zero both at SEBI and at the appellate tribunal. Successive, I think, regimes in SEBI have tightened it so much that it's kind of, they excluded fraud, insider trading and takeover regulations from the remit of what is consentable. And they are the only three things which actually require bandwidth.
Correct.
Technical violations, I mean, if there's a delay of filing forms, that's not really taking judicial bandwidth. So the entire kind of consent process came to a halt, and we've had a huge backlog. I think the current chairman is looking at reducing the backlog, so they've actually amended the consent regulations, and they're effective from 1st of January 2019. So with that, I'll kind of, how do we kind of, Bhargavi?
Yeah, sure. All right, this is great, thanks. Now, I had some questions, so I'm going to exercise my prerogative as moderator and then open it up. So, one area that I would request any of you, and Judge, I would request you also to join and, add to our knowledge if you have insights on any of these. So in India, we have, and you've written extensively about this, Sandeep, we've diluted the standard of fraud. I think Justice Sri Krishna talked about it a bit. And how do you see that in terms of, how does that play out in terms of penalties for PFUTP or in the previous regulations versus these regulations? Do you see disproportionate enforcement? Do you see under enforcement simply because it's such a wide definition that the regulator doesn't want to resort to it except in extreme cases? How do you see that playing out?
So as Justice Sri Krishna said, the definition of fraud is very, very widely drafted. So in fact, the 5 elements of common law fraud, of misstatement of fraud, none of them are applicable, and 3 are in fact very explicitly excluded, that damage is irrelevant, intention is irrelevant, causality is irrelevant. So I think they've kind of, but having said that, I don't see that as too much of a problem practically. I mean, it's such an abstract and inchoate thing when the 5 elements of fraud are not required. But in practice, I have not seen a problem in terms of SEBI kind of going after people who have not committed fraud. There may be other issues. Where I have seen a problem is with the definition of insider trading, and
That's another thing.
and that's a huge problem, because people are so scared. I mean, that's good business for us, but people are so scared of doing honest business. People think 100 times before doing a deal, before doing private equity deals. Who you can talk to is honest communication with a company insider. Asking about sales could just be an insider violation, insider trading violation. So the scope has become so large that it's actually harming honest conduct, which I think is a problem.
In this, passed about 2,200 orders. All of these are in the nature of non-monetary penalties. They are primarily directions which involve restricted market access or freezing of assets, warnings, etc. And there we surprisingly found that the number of insider trading violations related orders was surprisingly few, largely in PFUTP. So that is just, but maybe a sample, I mean, of course it's early research, our sample size wasn't so large, so maybe if we dig further, we'll be able to find things.
Just a quick comment. No, so that's absolutely right. So on average, I think it's around 80 to 90 insider trading cases by SEBI per year, which includes both penalty cases and the remedial provision which you just mentioned. Fraud cases end up being larger number because they often go, they go after a lot of people who are doing the same thing. So for instance, I don't know the number, but there probably like 2,000 or 3,000 people who did some stock market trading very recently. SEBI has sent show cause notices to 2,000 people for long-term capital gains, basically a tax advantage they've got. And they kind of also, they're passing orders pretty quickly, but that increases the number by 2,000, whereas your insider trading case requires a lot of diligence. You need to prove it. It's much more difficult to kind of tackle.
Now, Sandeep, one thing, you talked about this provision by which you could do a settlement. I had an interesting experience when I was doing the FSLRC. I had an interaction with all the regulators. The earlier chairman, I think it was Mr. Sinha, he came to me and he said, "Sir, what is happening is no officer in my unit is able to take a decision because he is scared of the 3 C's, the courts, the CAG and the CABI. So any honest order that is passed, he says, we are scared because the CBI will come after us and say that you have passed this order dishonestly for illicit consideration." Now, and he was saying, can't we have some kind of protection in respect of action taken by the SEBI officer? I said, hey, I know, as far as I know, judges are protected. No other person in this country is protected. You take your chance.
Rack up a lot of convictions or findings of liability or findings of wrongdoing for things that might be not large offenses. That looks good at some level, I suppose. You have a lot of action, which is important if you're trying to create credibility. But also at the same time, there don't tend to be that many large-scale frauds in a given year. I mean, there are some, of course, but if there were lots of large-scale frauds going on in any given year, then you would probably have a meltdown of your market. That's just sort of in the nature of how these things run. So that large-scale frauds, although not uncommon, are not, day-to-day occurrences typically. Another sort of interesting thing, I guess, about thinking through securities enforcement in particular is how closely you want to review what the regulator does. Some of the comments that both Sandeep was making and that Justice Sri Krishna was making are about the degree of review you give to securities regulators' decisions. And it's a difficult call, of course, for judges for precisely the reason that Justice Sri Krishna made, which is one of the key logics to establishing a regulator is that you believe they have expertise that is not otherwise possessed in the system. So then why would you have a part of the existing system supervise the expertise that they, ex hypothesis, don't have? That seems strange. That doesn't mean they can't be reviewed, or you can't at least assess what they're doing. So there are lots of ways to assess what a securities regulator is doing, not just simply by the size of the market or the number of frauds that are found or prosecuted, but also about how they meet up to global standards. To what extent do you see investment capital flowing to your jurisdiction, or does it flow away? If you're finding it difficult to, have capital allocation occurring in your country, that suggests that there's something wrong either at the pure fundamentals or that you're doing something on the regulatory space that scares people. One interesting development in the US, for example, is over the last 12 to 15 years, we've seen a reduction in both the number of IPOs and in the number of publicly traded firms, which is quite large. Prior to 2002, you'd estimate that the number of publicly traded firms would be in the order of about 5,500. Nowadays, I think most estimates are around 3,800. At the same time, the number of IPOs and the amount sought in IPOs has reduced. Even the identity of the firms doing IPOs has changed. It's much more likely, although not a massive likelihood, that you would have something like Facebook or Google doing an IPO when they're worth over $1 billion already. It doesn't appear that the IPO route is, at least in the US, is the primary method of raising capital now. Indeed, I would say the primary method of raising capital is private placements. Why is that? Well, private placements have less regulatory burden, and it appears with a series of other regulatory changes are easy to actually trade. The liquidity of private placements has increased dramatically in the US, allowing for a lot more fund money to come in, a lot more foreign money to come in, which essentially means firms don't need to do an IPO to raise capital. They can raise lots of money without ever going public. Indeed, some of them might think going public is a simple chore, because it's like, what are we actually getting by going public? If we can raise $300–400 million in the private markets, how much more do you need to expand your business? Raising interesting questions about what does that tell us about the regulatory structure that's at play. So you can learn things by observing how both the market responds, but also how other regulators respond to what you're doing. So that it doesn't have to fall entirely on the courts to try to resolve this, but they can take judicial notice of the developments that are occurring that might be relevant.
I have one more comment to make. One of the functions of any regulator, whether it be the capital markets or insurance or even the Reserve Bank, is to educate the regulatees. Now, if I have a genuine problem and I go to the regulator and say, hey, I'm not sure what I'm required to do. Can you just help me out? Is it right, or am I on the right side of the fence or wrong side of the fence? I expect the regulator to tell me and say, yes, you are on the right side of the fence. Fine, no problem. Or say you are wrong on this issue, you better do something else. But I find that our regulators shy away from that. They can tell you, they will tell you orally. But you said, why don't you address a letter to me? I address a letter to you. Say, no, we can't put it down in writing. You do whatever happens. If something is wrong, we'll catch you. That is not the attitude. I mean, it's like your policeman in US standing with the gun. What do you call that? That chase. And then waiting for you to speed and then shoot you and then say, okay, now you are, buddy, you are up. That's not the attitude of a regulator.
That's a really interesting point, because that is one respect in which US regulators, especially in the security space, are more open to doing things. You can have no enforcement letters that essentially say that, at least in your case, what you've revealed to us thus far suggests that we will not pursue an enforcement action against you. But we do have that in India. It's not clear it's used with the frequency as in the US. One can speculate about that as to why that might be. I will say, in a sort of in a related context, I was doing some research on why is it that tax litigation in India is basically results in the government losing most of the time. Depending on which numbers you look at, it's somewhere between 75 to 85% of all tax litigation the government loses, which is remarkable. It makes you wonder why they bring it. one of the interesting things about that is if you start looking and speaking with people in the field, a lot of the tax officials actually know that these suits are junk.
Absolutely.
Oh yeah, they're absolutely aware of it. But they're unwilling to actually dismiss it or stop it or whatever, partially because, at least some of them say this, or many of them say this, that they're worried that if they dismiss something, that will be perceived as them of having
Colluded.
colluded.
Let's
essentially.
be honest
That's-
about
yeah,
it. That
yes,
is exactly
colluded.
their fair.
The colluded or received some kind of kickback from the person
Yeah,
who's being
correct.
sued.
Correct.
So as a result, they say, well, it gives us cover if we simply let the court decide, because no one will question the court on this issue, but they'll question us. So why make our lives more difficult? Just let
Absolutely.
it. Now, of course, the downside of that is it has exactly the effect you identified, which is, even though they have the power to do this,
They don't do it.
refuse to do it. The downside, of course, in addition to that, is that means there are all these cases
It's
that
piling
are
up.
worthless, that are basically clogging the system because people, for whatever incentive reasons, are unwilling to actually say no to something. That suggests that we need to think about how we're assessing or monitoring the players within a regulator so that we don't deter them from actually making decisions we think are value enhancing.
Vikram, actually, now that you raised it, in the tax jurisdiction, in the Income Tax Act, there is a provision for advance ruling.
Yes, exactly.
Advance ruling authority. Now, you don't have this in any of these other regulatory jurisdictions. So, and the advantage of the advance ruling authority is that whatever is decided by the advance ruling authority is binding on the revenue. But the assessee can always challenge it. Now, if they had a similar provision under any of these regulatory provisions, I think that would make life far more easier.
So, sorry, but just to jump in, Sandeep, would you equate this to the informal guidance mechanism, a bit like that?
Yes, so I mean, so we have no action letters and informal guidance under SEBI regime. Why people don't use it all that much, I'm not very sure. Maybe because it takes some time. But I mean, we advise our clients to use that route whenever they, whenever they want to be cautious. But it
Can
certainly
you apply
takes-
for a no action letter?
Yes, yes. So-
At least SEBI has that.
So-
Reserve Bank doesn't have even
It
that.
doesn't have that. So no action is extremely rare, but informal guidance is quite common.
Okay. All right. So now I open it up to the floor. Anybody having questions for Judge Ken Jordan, Vikram, Sandeep, Justice Sri Krishna? Just go for it. Okay, I'll start with Professor Pradeep Yadav.
So I have a question from Judge Jordan and Justice Sri Krishna, which is in relation to the system for appointment of judges. Having grown up in India, my perception is that the appointment of judges in India is largely apolitical.
Right?
And it is done by a process which is either moves up the judicial chain, but in any case, it may have some concurrence with the political executive, but not too much. Only at the last minute and only as a kind of final endorsement. I somehow feel somewhat uncomfortable in the United States about the fact that the judges are appointed by the party in power and by either the Democrats or Republicans or on one side. And of course, it's come more into the focus in the more recent past with the very overt appointments which have been taking place in the Trump administration. But then even otherwise, security regulation, for example, does involve some element of your orientation, economic orientation, political orientation, how you adjudicate on matters is conditioned by your thinking in that context. So, what do you think about the two systems? What do you think is really should be the sort of normative position here in terms of what we should do? And my second question is, my understanding, Justice Sri Krishna can correct me if I'm wrong, my understanding is that if a case goes up to the Supreme Court in India, it is actually taken up. And it is not that, I'm kind of surprised by the fact that in the United States, the Supreme Court would say, well, we will take up these cases, but we will not take up these cases. And the cases which are not taken up are essentially just left to the final order from the previous court. It just left. And of course, the cases which are taken up in the Supreme Court are very few. So again, what, am I the only person uncomfortable about it? Or what's the position?
Thank you.
Thanks. So taking those in order, and first, the political aspect of this has gotten a little more extreme or in the public eye in the recent past. But that's that takes us in a very interesting direction. That is, in some measure, because of a failure from the other branches of government, particularly the legislature, to be step up. The Congress will constantly pass very broad legislation and then say, and now you, SEC, make rules, or you, Environmental Protection Agency, make rules, or you, Department of Labor, make rules. So instead of actually legislating, they make grand pronouncements and then leave it to the regulatory bodies that come up with enforceable law. When you do that and you take the opportunity for people to have a say in the formation of law out of their hands by putting it into the hands of unelected people in the bureaucracy, you can't take politics out of the system. The politics finds its way into the system to some degree, the appointment process for the judges. That's my theory. I don't know if it's accurate or not, but my impression is when you turn things from legislative policy-making questions into legal battles without giving an opportunity for people to have a say in it, you are going to make the appointment process more political because people still want to have a say. And that makes itself most manifest just recently in the Brett Kavanaugh, Justice Kavanaugh confirmation battle, which was a big deal in the United States of America. Now, to show that this has application right in the field we're talking about, last week, the Supreme Court, talk about inside baseball, last week the Supreme Court heard argument in a case called Lorenzo versus SEC, in which, without getting too deep into it, it has to do with the division between primary and secondary liability. A guy who had, at his boss's direction, sent out an email touting an offering which was a completely lousy offering and in fact false. And so there was not a question that there was some bad acting going on there, but the question was, could this guy be liable as a person who was not the creator of the message, or in the face of an old, not that old, but a previous Supreme Court opinion called Janus, was this guy going to get off and scot-free? Justice Kavanaugh wrote the dissent in the District of Columbia Circuit saying, Janus tells us in other cases like it that this guy cannot be liable under that section of 10b-5. He can't be. And you're messed up in saying he is. You're just trying to get around existing Supreme Court precedent. Irony of ironies, that case might end up being upheld because Justice Kavanaugh has had to recuse himself because he was on the court below when it came up. So it'll be a 4-4 decision probably. That's the betting anyway. And so that decision will be upheld probably along strict partisan lines. Conservatives on one side, liberals de-appointed versus Republican appointed on the other. And when that kind of thing happens, it's not good for the system because it creates in people's minds the impression that you're home team in it. I want to say emphatically, I've worked with judges appointed from both political parties now for going on 16 years. And I've never seen one of my colleagues, not one of them from either side, act in a way that I thought they were there representing a side. That doesn't mean that they didn't, as you said, they bring their perspectives to it, and you can see that sometimes, but never anything overtly political, for which I'm extremely grateful. Long and the short of it is, I like the way the system worked. It gave me a job, but I think, thoughtful, well-intentioned judges, which are the vast majority of them, are not letting the political interests sway them. They're just trying to honestly do their best to get the law right. I don't know if that was more of an answer that you were looking for or not enough, but that's where I come out.
Pradeep, two questions you asked. The first question was, judges in India are apolitical. Absolutely, there is no doubt about that. In fact, I personally believe that the judicial oath which you take requires you to switch off your mind with regard to all political doctrines. I have had, I do not know if you remember, way back in the 80s, one of the judges went on a public platform and said, the only manner in which this country can survive is bringing in Marxism. Now, that according to me, my personal thinking is running away from the judicial oath. The judicial oath was that you would be true to the Constitution and the laws made thereunder and enforce them without fear or favor. Now, if you come out with this kind of a statement, and if you have that kind of a feeling inside or express it or not, that is running away, deviating from the judicial oath. That is the reason why a person who takes an oath is required to switch off all other considerations, look at the material before him, with judicial conscience, and decide. Second question, you asked me about the right of the cases which travel up to Supreme Court. Let me tell you, when I was a judge of the Bombay High Court, there was a delegation of American Supreme Court and Federal Court judges who came to India, and their mission was to teach us case management. There was this lady, I will not name the lady, the Supreme Court judge, who were all sitting on a round table. She was sitting next to me. And I just casually asked her and said, ma'am, how many cases do you decide in the Supreme Court? She said, in a bad year, it's about 100. So how many do you actually hear them in the court? Not more than 10 at the most. I said, very good. Now listen to my story. I write 2,500 judgments in a year. If I don't do that, I'm considered a bad judge. It's 2,500. Oh my God, how can you do that? I said, I've survived and I hope to survive till I'm 90 at least. Now that is the difference. Now the reason why everything goes to Supreme Court is people don't realize this. Way back when I was a young man practicing in the High Court, we used to read the Constitution. The Constitution has several provisions saying that, if you remember originally, an appeal to the Privy Council had to be by a certification. So the division bench of the High Court had to certify that this case raises an important constitutional issue or a question of public law of public great public interest. And if they didn't do it, the matter would be disallowed. If it was disallowed, there was a residuary provision under 136, Article 136, where the Supreme Court, if it considered it extraordinarily necessary to interfere, would interfere in that. Now, 136 has become a regular third appeal. The Supreme Court interferes within everything, pollution control, and what should be the pressure in your tires, what should be the... Somewhere I read in the newspaper that they were deciding the dimensions and contents of samosa in Delhi. I think that... I was inclined to believe because whatever they are doing, it's possible that they might be interested in that also in an excise matter. But ultimately, sitting on the bench of the Supreme Court, it used to irritate me to people, if I saw people who came under 136 for adjournment not granted, cost granted, matter not being taken up. I said, why are you wasting my time? I already have 100 matters to read before I make up my mind. That is why on Monday and Friday, the judges really have back-breaking work for the simple reason that we don't decide by circulation. We have to read each matter, give an oral hearing to the counsel, and in order to give an effective hearing, we have to do homework. If you have not done the homework, the counsel will keep on arguing for 2.5 years, and then you will not come to the end of that. If you have done the homework, you say, come straight to this point, what do you have to say? But we discover at the end of it that 95% is junk. It is not worthwhile admitting. And 5% perhaps gets admitted. So I, as a maverick judge, when I became a judge of the Supreme Court, put forth a suggestion to the Chief Justice. I said, Chief, look at it, what happens. Now, three classes of petitions come up under, I'm talking particularly of 136, Article 136. Either they are hopelessly useless, we are going to throw them in any case, or they are so good they need to be admitted, whoever appears for them. And some borderline cases where a little bit of argument may be necessary to persuade you one way. So I said, class 1 and class 3, why don't you decide by circulation? So that our burden is reduced by at least 2/3. The answer given was, oh, the bar would raise a howl of protest. I said, good luck to you. If you keep on bothering about the bar raising a howl of protest, we will never be able to solve the problem which is plaguing the courts today. And what is true in Supreme Court is equally true in the High Courts.
So I think the principle of golden mean, which we spoke about for enforcement, over enforcement, under enforcement, I think it's equally applicable to
Judges also.
yeah, admissibility. All right, Pratik had a question.
Yeah, so my question is to Vic, and I just wanted to take off from the earlier discussion where I think Sandeep, you mentioned about SEBI being set up. So actually, if you look at all other financial regulators currently, so RBI in 1934 was an interim measure. IRDAI was also set as an executive agency and then an ordinance and then a statute. PFRDA again as an ordinance. The only exception was IBBI. So it seems like as a matter of general principle, regulators are always set up as an emergency measure in India, in the financial sector. So, and that's where Justice Sri Krishna also mentioned about the knee-jerk reaction, right? So it's not just in securities law. If regulators can be set up as emergency measures, then I'm not surprised that securities fraud regulations are always emergency measures. So in this context, my question was a bit institutional in the sense that why is it that there is a lack of evidence-based research in India because we tend to make policy as a knee-jerk reaction? And is that a reason why you do not have demand for good legal academics in India? Because anyways, it's not based on any great reasoning. So if that is not the case in US, what is the institutional condition that leads to a demand for evidence-based policymaking and therefore of legal academia?
Oh, that's a broad question. Thank you.
Let me just switch it on.
Oh, that would help.
It's the
The light is on. Yeah, it's on.
Thank you. So, although I'd agree that there's a lot of regulation that occurs in India as a result of, either symbolic gestures or knee-jerk reaction, you need to be appearing to do something. That could well be said for a lot of regulation everywhere. If a lot of people, when Sarbanes-Oxley came out, their initial reaction was, this is quack corporate governance. Indeed, there's a very famous law review article called Quack Corporate Governance, and that was debating Sarbanes-Oxley. The comment that the judge made here about, passing a law that's broad and let the regulator fill out the details, that would be an apt description for Sarbanes-Oxley in some ways, right? So that, and indeed, if you look at the history of financial regulation generally, what it looks like is crisis followed by regulation. One could view the 33 and the 34 Act in that same spate too. Rumor has it that Justice Frankfurter wrote the 33 Act with a couple of colleagues over a long weekend. It's like 17 sections, right? And there are parts of it that are mystifying. Like, for example, they regulate the public offering process, but you can't find the word public offering in the 33 Act. It's not defined. That condition is seen in other areas of securities regs too. The Williams Act in '68 is about tender offers. You can't find the word tender offer in it. It's not defined either there, so they leave it to the courts or other people to come up with it. I think the dynamics of regulation in some areas is such that it's the centripetal forces of inertia make it much less likely that regulation will occur unless there's a crisis that pushes the current constituencies to do something. Now, what does that mean in terms of what we see or don't see occurring in India for legal academics? So I think, it's interesting. I'm not a grand historian per se, but my impression is that if you looked at the legal academics in India in the 1950s, 1960s, the general sense was that the degree of legal scholarship that was being produced in India was serious. And indeed, the leaders of some of India's best law schools over the last 20 years were Indian legal academics in the 50s and 60s, Madhava Menon being perhaps the most notable of the lot, but many others too, Upendra Bakshi and others. So that I wouldn't necessarily say that India's overall regulatory system kills off interest in legal academia. I would say that that is a recent unfortunate aberration, shall we say, a frolic and detour, hopefully, from the norm. Why is it stronger in the U.S., let's say? I think there are a lot of institutional reasons for that. One of the upsides of being in a fast-growing emerging market is that the economy is changing fast. One of the downsides of being in a fast-growing emerging economy is institutions typically don't change with that speed.
That's right.
So that keeping up with things is hard. Whereas in the U.S., they had the luxury of time. You don't always feel that when you're working in the U.S., mind you. But as a general matter, they had the luxury of time in adapting the regulatory structures to an economy that evolved over 2 centuries. The goals India is setting for itself, and many emerging markets set for themselves, don't necessarily suggest that, it suggests you'll need a much more turbocharged institutional change structure to keep track. That actually suggests legal academia would be very valuable. I think as people think about institutional structures in India, both social and legal, the value of legal academics should increase more because they're the ones who probably have a much more deep understanding of the interaction between the various institutional structures in society. Indeed, one of the values of a lawyer and a legal academic is understanding that social, historical, political context, which makes them invaluable in that regard. And for those of you who would like to pay me money for just having grown the demand for legal academics, please feel free to do so.
Yes, I just have to supplement what he's saying. So I think a lot of the problem is not just the niche of bit, but even thoughtful stuff has created mayhem, and all from private sector. The 2 things which we just discussed, insider trading regulations, committee made entirely of private sector people. We just discussed the anti-fraud, the 5 elements of fraud in common law. T.K. Vishwanathan committee, all private sector. Just 1 or 2
except T.K.
bureaucrats.
Vishwanathan.
Yeah, except 1 or 2 bureaucrats.
Bureaucrats. Yeah.
All the others were private sector.
No, the question that is when a committee consists of private sector representatives and the bureaucrats, do the bureaucrats rule the roost? That is the question.
No, sir. I believe, at least I know insider trading. I know that it was done by private. So I think the fundamental problem is academia in India is not deeply connected to policy making. You guys are changing it, I'm sure. But till that happens, the depth of understanding, it doesn't require a lot to figure out that fraud requires these 5 elements. It's been around for 400 years, right? That it should apply, the same thing should apply. I mean, there may be exceptions, like you have presumptions of causation, etc. So you have exceptions. I mean, fair enough. But the broad principles should apply. I mean, it doesn't take too much of depth as well. But the industry is not ready for it. The parliament is kind of too big picture to look at the detail. But I think unless till the time academia gets into policy making, this problem will survive.
So then I'm confused. I'm just going to take 1 minute. So if the insider trading, the committee, the Sodhi committee, if you think it was disproportionately influenced by the private sector, wouldn't we see insider trading regs on the other side of the spectrum where, where it would be very, very easy to basically, resort to that conduct, whereas in the conversation, you mentioned that it is even good faith conduct can easily be prosecuted. So I'm a little confused. How does that match up? So, or are you saying that the disproportionate influence was that they went to the other side of the spectrum where they said that let's be absolutely safe and recommend that? Is that how it worked out?
Yes, I think exactly that. It's so overbroad, As we discussed with fraud, it doesn't require any element. Walking is fraud then. Insider trading, any conversation with an insider of CEO, chatting with the CEO or dinner, I have to be really careful what I talk about.
You're talking about having dinner with an executive. I will tell you an interesting story. When I was a judge of the Supreme Court, I decided a case of one of those private gutka fellows. Whether the gutka, the order was valid or not. After a long debate, I held that the order passed by the state authority was invalid and I struck it down. Then next day morning I read in the newspaper that the share value had risen up by about 400 rupees. No, I was just joking with my law clerks and said, if you had gone and invested in this share of this, you would have made a lot of money. Then there was a debate whether it would be insider trading. Of course, the regulations were not in place in those days.
Right. Okay, who else has questions? Because otherwise I'm happy to talk.
Somebody's asking questions.
Hello. I just want to state an observation and then I'm going to try and phrase a question that's addressed to you, sir. If it does not make sense, please feel free to
Say so.
say no. So picking off from what you were saying about insider trading and how overbroad it's drafted, I was just reading an order the other day, and this was the case. So insider trading under the regulation is through connected person or person possessing
Unpublished sensitive.
unpublished price sensitive information. And so it's an interesting case. So SEBI charges two people on the basis of the second leg of how you become an insider, on the basis of unpublished price sensitive information. And their basis is that the person is alleged to have this information because they ended up liking two pictures that the target posts on Facebook. And that is the tenuous degree of connectivity that brings forth SEBI's charge against you. Anyway, that's the observation. The question is, and this takes off from the incident that you were talking about, where you dissented in the judgment. My question is, as far as disgorgement is concerned, and as far as your concern as to when it could spill into becoming a criminal penalty, is it better can one jump this by simply saying that disgorgement is more of an equitable remedy, and then say therefore SEC is within its rights to ask for it? Because my understanding is that the US Supreme Court has held that SEC is capable of enforcing equitable remedies.
Thanks. Yeah, there's no question that the SEC has the power to do that, and they do. It may be the major administrative kind of, it may be the major remedy they seek in civil cases. It's a very powerful, and they're allowed to do it. I use that as an example because it is, to me, a prime instance of taking your power and going beyond what the law actually provides. The disgorgement is supposed to be, by definition, it's restitutionary roots, right? Its roots are restitution. That's why it's an equitable remedy. You had something, now give it back because it wasn't supposed to be yours, restore it. That does not mean give back and then give more back. That was the problem. It wasn't simply that he was required to give and disgorge those portions if they could have proved it, because the burden of proof was on the SEC, what his ill-gotten gains were. They said, give everything back, and it doesn't matter that we acknowledge that some portion of your gain had nothing to do with your wrongdoing. It had to do with the tender offer, which was everybody admitted was completely unrelated. So it was the SEC. Now, I'm sure if there was somebody here from the SEC, they'd say, we got that all wrong, Jordan. You had it wrong then, and you got it wrong now. But my take on it was, they just didn't want to go to the labor of proving this was what the restoration piece had to be. They wanted it all, and I was disappointed that my colleague said deferred to them. Part of the problem is, and we heard a little bit of this from Justice Sri Krishna, it sounds like in India you've got an example of the Chevron doctrine that we've got in the United States, which is you just defer to the agency, and that's not what we're supposed to be doing. We're supposed to be saying what the law is, and we should have held them to that, because when you let them go beyond it, you get the overregulation, which deters sensible, good behavior. This is goes beyond this a little bit, but I wanted to something that Vikram said about the movement of private capital or people going to private equity instead of going to the capital markets that was actually something I'd written down in here, and I saw I was running out of time. I just skipped over it. Query whether that's good for society generally, right? There's a real big question about that. But when you get these heavy regulatory hands on the levers, people, I think, rightly say, I can get the money here, and I don't have to mess around with all that, and I don't need it, and I'm not so sure that's overall good. And you can see it also, to a certain degree, in privatization of dispute resolution, because as it gets more and more expensive in the United States to litigate these things, people move to mediation and arbitration, which then sort of retards the development of the law itself. So there's all, we got problems in our system for sure. And I don't want to make it sound like it's just all over-regulation. Sometimes it's under-regulation too, but in this specific instance, the problem was, in my view, not that they couldn't get a disgorgement, but that they asked for more than they should have, and they got more than they should have.
8:58. Okay, that was great. So I just want to make an observation that of late, the number of consultative discussions that financial sector regulators are having has definitely increased. However, the process is not complete. This is in the context of regulatory capture and whether regulations are made by some group of people versus everybody else. But it seems like while some regulators, for instance, in the infrastructure sector, we see regulators putting up the comments that were received. A recent Supreme Court judgment struck down a regulation issued by a telecom regulator, one of the grounds being that there was no reason given for not taking into account some of the comments. But we don't see that happening for financial sector regulators. We don't see that threshold of review for financial sector regulators. And to that extent, we follow the Chevron doctrine much more than, say, the US. Whereas for the US, I believe, after 2008, the Chevron doctrine has been diluted consciously by the courts. And, for example, the MetLife's designation as a SIFI was challenged. Would you say that, or is that a fair assessment?
Yeah, there's pushback on Chevron, but it's not diluted yet. There's some prospect that, and this goes to Pradeep's comment about selection of judges. It matters who's on the court. Justice Gorsuch has expressed serious reservations about deferring to the agencies on a regular basis. Justice Kavanaugh has expressed serious reservations about deferring to the agencies on a regular basis. Well, now, and that's candidly, I think, one of the reasons he was opposed so vociferously, because he might be the fifth vote on something that's very important to people on the left side of the political spectrum, which is continuing to empower the agencies, and there may be a cutting back of the power of the agencies. And it shows up in this, that Lorenzo case is in fact an instance that I mentioned earlier, a case about cutting back the power of the SEC. And so you see these things playing out where philosophical differences about the administrative state are right now one of the real, in my view, hot issues in the law in the US.
All right, so we're out of time, and I don't want to stand between everybody and dinner, so I'm going to call this a day. But I thought this was a great discussion. I mean, this is the 9th year of the conference, and we've never had a panel that is dedicated to securities, regulation, enforcement. We have all these, liquidity and market efficiency issue-related panels, but never on this. So this was great, and I think the audience has been a great participant, so thanks, everybody.